Hey guys, so I want to thank you for tuning in today. What we're going to talk about today is the role of marriage and family therapists when approaching divorce related legal processes and ethical considerations. So there are four areas where we're going to cover today. And those key points in those areas, they're going to be the divorce process, child custody, considerations for evaluating um, child custody arrangements or mental health caregiver, AAMFT code of ethics that will have to do with those types of considerations, and tips for information relating to when you would be subpoenaed as a practicing MFT. So, as a practicing MFT, we're mental health professionals that may be enlisted to aid a family in reducing conflict during the divorce process. So, the pricing, the length of time that it takes for the divorce process, that's going to vary from state to state. So, in a nutshell, once divorce proceedings begin, one party will issue a petition. And the petition is pretty much just a written petition by one spouse or the other. And it's going to be filed in the state that that one of them resides in. It doesn't really matter if their marriage occurred in that particular state. The petition is going to include information regarding the marriages, and it's going to name the husband, the wife, any children, and it also states if there's any separate property or community property, as well as child custody. So that's kind of how the first pieces of divorce work. And the final stages of divorce, both the spouses, they're required to disclose information regarding their assets, their liabilities, their income, and expenses. And if the divorce is uncontested, then the spouses, they can agree on the terms of the divorce, and there is only a little bit of paperwork to file. And once the court enters into the judgment, the divorce is final. So there is, however, a marriage is also formally and officially dissolved um, if the spouses cannot remarry until the end of the state's waiting period. So if there's any kind of disputes or anything like that that cannot be resolved, then there can be court hearings, and then there can possibly be a trial required. So, as far as child custody is concerned, what happens when two parents are, trying to decide what type of custody each parent gets and who has what rights? Well, when a marriage and family therapist, as a marriage and family therapist, we can be subpoenaed um, when if certain things do have to go to court. So, according to the AAMFT, a marriage and family therapist, they fit into that role of the expert witness. So, the family therapist must be aware that they may be subpoenaed by either the client, if they're seeing the client, or the client's attorney. And as a practicing therapist, we also should always be aware of the different reasons behind why somebody may want us to testify during court proceedings. One dire reason an MFT is going to be most likely asked, obviously, is kind of to chime in on and render some sort of opinion on who should receive custody of the child. As a practicing marriage and family therapist, you can be considered an expert witness. So that's why you would be able to be subpoenaed or be called when when the spouses are unable to decide how to split custody of the children that they have together. The therapist can also present a quash order to the court if there is some kind of fear that that testifying in court may hinder your therapeutic process, or it may compromise any type of disclosure um, regarding specific information. So once it's decided to release information, the client may work with the client's attorney um, in order to prepare their testimony. So if you are subpoenaed for court, you could be subpoenaed by your client that you're seeing, their attorney, or you could be subpoenaed by a client that you're seeing, their ex spouse. And that's the type of situations that you want to be aware of. And when you're making decisions, you always want to be aware of what are the reasons why they're asking you to testify. It's also a good rule of thumb, just to be prepared for any kind of questioning during the process. And when you're going into a court and it might be sort of an aggressive battle, that particular attorney can also walk you through how things are going to go in court. There's never any definitive way that things are going to go in court, but just as how ordinary things that may take place. Depending on what stage of the divorce the client is experiencing, that's going to determine what type of intervention you're going to be providing if and when a client does seek out help to aid in their divorce process. So if a client does make that decision to seek you out as a marriage and family therapist, there's many different options to aid that client through the divorce process, which would be there's a mediation process. There's also a collaborative divorce and co-parent counseling and parent coordination. So I'm going to briefly go into what those mean, and that's kind of going to help you decipher even whether or not you're going to aid the client. And then if you are subpoenaed for court, this is also what stage of the divorce is going to help you to be able to know what you can provide if you need to go to court, as far as information and in support of your client. So mediation, as defined as a short-term or a structured process that focuses on building agreements regarding co-parenting and financial issues, things like that. Collaborative divorce, that's pretty much the approach where the divorcing couple and the attorney, they agree on a written contract. They've worked through the settlement without resorting to litigation and without going to court. So each person is they're represented and they're specially trained by a collaborative therapist or a collaborative attorney. Sorry. And there's also the stage of co-parenting counsel, and that's when the parents have separated for divorce, but they continue to struggle with communication and making decisions with one another regarding their children. And a mental health professional who has experience is going to start working with the families post-divorce. There's parenting coordination, and that assists former partners who can't resolve their disagreements, and they kind of need intensive aid and help when communicating with each other and their children. So with those items, it's just important that you remember that when you're going into, if you do decide to go into court and you would like to testify, then there's always an issue of remembering that you want to know why you are sought after, and is it in the best interest of the child if you're going to testify on behalf of child custody. So now that the MFTs have taken that type of thing into consideration, There's also looking into how is the caregiver? Is the caregiver fit? Is their mental health okay? So the first area that you want that you're thinking about when you're evaluating that item is that first we should focus on the factors that are in the best interest of the child first and foremost. Then we always want to remember that we're well trained, professionals, and we have an extensive background in clinical training, so use it. Have an understanding of parental concerns. However, also be sure to always place, once again, that child's welfare first and foremost, even though you're taking into consideration the parental concerns. You want to utilize an evaluation that focuses on skills, deficits, values, and those types of tendencies that are pertinent to the parental attributes that they have in order to assess, is this parent mentally well to take care of this child? And also clarify what is wanted out of the custody agreement to determine whether or not you, as the MFT, are able to provide clinical opinions and recommendations. And then we also want to make sure that we are aware of what type of psychological testing or clinical interviews or behavioral observations the client has underwent. With ethical considerations that we want to take into account, there's informed consent, as far as the AAMFT ethics code. We always want to make sure that we have gotten the consent of the client to participate in therapy, and that we have consents for whatever it is that we need to discuss with other people. And that's where the multiple relationships code of ethics will come in, because the multiple relationships code of ethics, rule 1.3, it states that marriage and family therapists are aware of their influence, their influential positions, and that's with respect to their clients, and that they avoid exploiting the trust and dependency of such persons. And there's also therapists, they want to make an effort to avoid conditions of multiple relationships with clients that could impair professional judgment or increase the risk of exploitation. And those relationships can be business or personal or immediate family, things of that nature. One of the things that we're looking at when we are therapists and being involved in multiple relationships is not just family members, relative, this can be the family member's attorney in this situation, the family member's judge, things like that. So we just want to make sure that we're paying attention to that particular code. And then, and that also kind of falls hand in hand with AAMFT Code of Ethics 1.13, relationships with third parties. And you want to make sure that you're providing services to requested third parties once you have clarified and understand and are comfortable with releasing certain things that are confidential. Thank you for tuning in, and I hope this helps a bit with some of those difficult divorce situations. Thank you.